going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. Friday. You guys want to watch some court? I want to watch some court. Let's watch some court. All right. Hopefully you guys had a great week. Happy Friday. Hope you guys have some great plans this weekend. Let's see. What do we have on the docket for this evening? Got a couple landlord-tenant cases. Actually, we got 3 landlord-tenant cases, and then we have an idiot. Well, we got a lot of idiots. Let's be fair. First guy. I talked to a couple Hutch about this case because I showed him this case as well. I'm like, is this a SovCit? And him and I are on the agreement that he is right there on the line of a SovCit. I think he is one. I think we're going to find out more at the trial, and this is in front of Judge Johnson, and I believe she does her trials on YouTube. I've seen a couple of them, so hopefully she has his trial. But he says some very SovCit adjacent things, and demanding a jury trial for a landlord-tenant case, yeah, that's a sign. That's a sign. That's a weird move. It's a weird move, man. All right. You guys ready? I'm ready. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Number 24-12369 LT 42 West versus DK Inaya.
Ooh, Judge is loud. I turned the volume up a little bit because you can't really hear the podium too well. But so I turned the volume up so you could. Probably should have kept the judge down a little bit.
Your Honor, James Farmer, 63.
Okay. What's your name, sir?
DK Inya. Yes, myself.
All right. Thank you, Mr. Inya. And so we're here for, let's see. We're last year on this. This is a landlord-tenant hearing. It's a motion apparently to set aside a default judgment, but this is not a default judgment. It's a consent judgment.
Your Honor, I actually would like to see. It's not the for me on this. Parties that actually but I did not get into quickly on this. So this should be set aside.
Okay.
With Mr. Yeah, did I say that correctly? Yes, with Mr. Inya. Although they agreed in an email that we don't agree today, so I'm for this
well, let's see. It's just something I can easily figure out, or I probably need to take some testimony.
You both didn't take this.
Okay, so we'll have to do it another day. So what we'll do, sir?
I think first of all, is we need to set aside the judgment.
Well, I was going to say that.
Yeah, and go over some other aspects of the case that need to be addressed. Because if the judgment is set aside, I was not properly served with the demand of possession. So I think that the whole process needs to be started over.
Okay, well then you want to have them reserve the whole lawsuit on you.
Have to do that.
Well, let me see. Let me see what your motion says.
We haven't really gotten into the case yet. Once they start talking, judge will say, please speak clear so we can hear you. They've just announced themselves right now, and the tenant is trying. They both agreed to throw away the consent judgment and essentially start over. But then the guy filed a motion because he wasn't served. It's like, well, you agreed to essentially start over already. But why did you file a motion to start over? It's, again, SovCit vibes. But yeah, I'll pause it periodically to translate.
He was agreeing to set it aside, but if you want it totally dismissed, let me see.
Well, the facts for the dismissal may be separate from the facts of the motion, but I can also present.
Sir, I'm not sure. So what I'm going to do is I'm going to read what you said so that I can be clear on what your argument is. Because typically, if you were served, but there was some other good cause or defense as to why you didn't come, then they're agreeing to set it aside, and normally we would go to trial. But if you're saying you didn't get it and you were never served
Heather.
at all,
I wasn't given the two services necessary. I was only served as a posting to my door. I wasn't.
that's okay in landlord tenant. You don't have to be served right to your hand.
I didn't get the mail service or the email service.
Sir, let me say this. The whole reason why we do the 2 or 3 is so that one of them gets to you. The only thing you need is something, what we call it is efforts that are reasonably calculated to give somebody notice of the lawsuit, because we don't want you to get a judgment you didn't know. Okay, so that's why we make lawyers that are plaintiffs counsel in these kind of cases do 2 or 3 different ways. So if you didn't get it one way, you get it the other way, at least you have notice. So is that your argument, that you got it one way, but you didn't get it the other two?
Well, just in terms of moving forward, I thought that was relevant because by the time I did get the notice to my door, it was just really days before.
So that's usually how it works in landlord tenant. People get it 1 or 2 days before, and then they got to get here. The idea is to make sure you at least have notice, not that it's convenient.
Yeah,
2 different things.
So legal.
Yeah.
Counsel or anything.
Well, I'm going to go ahead and grant the motion to set aside the judgment. Mr. Groomer says that there was some questions even about amounts that need to be worked out. Would you agree with that?
Oh, yes, definitely.
Okay, let's see.
Some other aspects as well I'd like to.
Hold on, let's do this one. Mr. Groomer, can you do an order setting aside the default judgment, please? So you want a written response as an answer, or we just want to set it for trial? Okay, so motion to set aside. Okay, let me tell you what I got.
Was there one, was this not the first hearing or second?
Let me tell you, just hold on.
Sure.
Yes. Guy in the blue coat's the tenant. Here, you know what I'll do? I'll do this. It'll make it
Yeah,
a
I
little
see. I think Mr. Palace's office was here for this before, and it looks like that was on February 6th. We had a hearing January 23rd. They requested adjournment then to confirm some payments had cleared and had been applied to the balance due. So then we set it for the 6th of February. On February 6th, a consent judgment of possession was entered. So he had agreed to it.
Yeah, I agree those numbers are wrong.
But the numbers were wrong, I guess.
They have.
And he had a payment arrangement
Yeah,
too.
they did. And Your Honor, but if we could just set this for.
Okay.
I would like to request a jury trial.
Why didn't you request a trial before? This is not our first time here.
Yeah, well, being that the consent judgment is being set aside, it kind of resets it to.
Okay. Sir, let me just ask you a question, and you certainly have a right. No one is ever going to take that right to a jury trial away from anybody. You know how to try a jury trial, though?
I'm sorry?
Do you know how to try a jury? It's a lot of work.
Yeah, I'd be bringing in.
You gonna have a lawyer?
Yes.
Well, why don't we do this? Let's let you get your lawyer and let's set it for a quick pre-trial so that we can have Mr. Gromer talk to him and we can define whatever issues we have here and set a trial date that's within the lawyer's schedule. Do you know who it is you're gonna have?
I am speaking to a couple of lawyers.
But you haven't decided yet? Okay, let's do a quick,
All right. Translation to I've been speaking to a couple lawyers. I want a jury trial. No. I mean, I'm sure somebody will take a landlord tenant action at a jury trial. I mean, there's going to be a lawyer that'll take your money. Sure, it's not happening, man. I don't believe that he's been talking to a couple lawyers. He's talking to his internet friends. That's what's going on.
Retrial then.
I would obviously request this for.
Okay. I'll make a note. The defendant requested a jury trial.
Your Honor, I understand people have counsel, but if he doesn't have counsel, obviously the reason I've asked you for the dates is he was here on January 20th. Assumption was that he was read his rights, like he does. So he would have 5 days to place that in. So that date would have been January 28th. March 20th is requesting it first.
Mm-hmm.
Believe that it's obligatory that you must do so.
I'm pretty sure I would have read those because we do this every Thursday. And what we do is have everybody sit down and watch the advice of rights video in the court. Then when I enter into the consent judgment, I ask you, did you watch the advice of rights video? Did you understand the rights? If you didn't watch it, I tell you what the rights are again. If you did watch it, I ask you if you understood the rights and if you wish to waive the rights. So that's why I asked earlier, why didn't you just ask for a jury trial then? But at that time you entered the consent judgment and thought that that was correct.
Consent judgment, once I reviewed the facts and had the pertinent information, I saw that it was incorrect. So going forward, I immediately felt that it would be probably my best interest to have a jury trial.
Okay.
But of course, I couldn't make that decision until I came here today.
Okay. All right. Well, Mr. Gromer, if you want to brief it for me, because right now we have a situation where he was advised of the rights. He entered into a consent judgment, which everybody agrees was wrong, which we've now set it aside to allow him to have a trial. So why can't he now ask for a, to have a jury trial?
This corporal is specific as.
So this is an interesting argument. In order to request a jury trial for a landlord-tenant matter, you have to do it on the very first hearing. The way that the landlord-tenant cases are set up in Michigan is the first hearing, you're advised of your rights, and you're given the opportunity to get an attorney at that point. It's generally adjourned for a week or two, and then you come back, and that's when the sides agree on what's going on. So to not waste time, you have to request a jury trial on day one and then pay whatever the jury trial fee is. It's like $100, and I don't know. But so that time has passed. So he already had his first hearing, he had his second hearing, entered the consent judgment. Now they agree that it was written incorrectly, so they set it aside. So the tenant right now is treating this as it's his first hearing again, and he's allowed to request a jury trial. It's an interesting argument. We'll see what happens.
So as the first hearing, I'll remind President first told court that he didn't have time for that consent judgment date, and we now find out there's a hearing days before that judge. So I know a lot of say this nice, not about a lot of truth in the courts and courts. So I don't believe the court will change my this year. Two separate occasions. An answer. The motion still hasn't done that in writing to request.
You know what? Because you're right. It wasn't just.
All right. The attorney's really difficult to hear. He pretty much just said exactly what I did, that he doesn't have the right to a jury trial, is what the attorney's arguing. The attorney's the short guy next to him. The bigger guy with the blue jacket's the tenant.
The first hearing that he did enter into that judgment, it was the second hearing.
The first time we came to court,
That's when I gave you the rights.
first,
Way back on January 23rd.
I think the proceeding was adjourned.
Well, yeah, but it was.
But at that time, I, in good faith, was looking to mediate this issue. This is my homestead. It's not a business. So this is where I try to find peace. Upon trying to mediate it, actually, I would say that the plaintiff is the one
SovCit argument number 1. This is my homestead. It's not a business.
that did not present properly to the court with the amount of settled this by now. But being that there are other issues like damages as well as injury to me as a defendant, with reference to the and I think that the relationship is irreparably damaged because I've been informed that although they offered me a lease renewal, they are going to be rescinding that. So I think there are some pertinent issues that need to be addressed and covered, and I think that I would like to do that at a jury trial if the court so pleases.
Okay. Well, we're happy to give you a jury trial if you're eligible, but there is a rule that says you have to request it on the first appearance or within 5 days of that first appearance, where I advise you of the right to a jury trial. So I'm not sure if you decided that you thought you were going to settle is a good reason not to have requested a jury trial just in case.
We weren't settling. We're looking for additional numbers to make sure that we have the pertinent facts that they weren't presented at that time.
Somebody's going to have to give me some law on this because he's objecting, so I'll ask him to do it. But what he tells me is that, which I know, is that you do have to request that jury trial on the very first appearance, no matter what you think you're going to do, or within 5 days of that appearance.
I didn't have an opportunity to do that on the first appearance because it was adjourned.
Sir, you could have gone downstairs and gotten the file and just filed it. It's just a piece of paper.
Well, we didn't, the proceeding didn't.
Okay, but I don't know that there's any exceptions in the rule that says about right to jury trial that you can say, well, I thought we were talking, so we adjourned it, so.
Well, no, not because we were talking, but because they didn't have the correct numbers.
Okay.
They didn't have the correct information to proceed.
But I don't think the rule has contingencies, is what I'm saying. That, okay, I was going to enter consent judgment. The numbers weren't right, so I didn't ask for a jury trial. I'm not sure that the rule makes exceptions for that. You have a little bit of a unique situation because you did enter into a judgment and now you're trying to set aside, which basically starts from scratch. So my argument or my question, I'm not arguing anything. My question is to Mr. Gromer, in that circumstance where it's obviously not his first appearance, but he had decided the case and everybody agrees it was incorrect. Does the rule does this make it like a new case? Because we just set it aside and everything starts over. So why couldn't he demand a jury trial? So if you could please just look it up for me.
I'd be happy to look it up. Obviously, he's the moving part. So we really his motion.
Well, you're objecting.
Well, I am because the first hearing, the rules that I obviously don't read the rules to any.
Right.
Here on the 23rd. Date would be 28. Something entering into a consent judgment. It's saying that a mistake was made, obviously. No, or isn't.
I'm not saying that at all.
Jury trial. Respond to that. Sure.
So he just requested it today. So you know what? If y'all want me to do this work, because he's not going to be able to do it, what I need to know. So I'll take it on. I'll do it. No, I'll do it. Don't worry, Mr. Grower. I got resources. You can look.
Execute motion with board.
Because he's not going to be able to do it.
Did it on the other one. Figure out this and I'm just making scroll. I do it.
Sure.
Your Honor, if I may.
Yes, sir. What would you like to say?
So for the January 23rd date, where there was an adjournment requested by the plaintiff lawyer, although the lawyer has changed, that was the adjournment.
No, it's not accurate at all.
I'm speaking, so.
Okay, well, let him finish, Mr. Grummer. What is it?
So being that the plaintiff attorney asked for the adjournment on the 23rd, it was an adjournment, basically, or continuance of the same proceeding on the 6th. Doesn't that count as a first appearance coming in on the 6th with relation to them not being prepared to proceed with their case?
No, first appearance is the very first summons and complaint date that you get served with, that you show up on. That, the one that we set, that is the first appearance. Anything after that is a second appearance. This is the third appearance.
I guess I didn't understand my rights then.
Yeah. I don't know why, because I show a video, and I show it every time. I have a full landlord tenant docket. We show this video. I know when I entered your consent judgment that I reminded you about what those rights were. You said, I know you said, yeah, I understand them and I'm waiving them. And they were the rights in the video, which one of the rights clearly says you have a right to have a jury trial. And if you want one, you have to fill out the form. I give you the form number. I tell you, you have to file that on your first appearance or within 5 days of the date that you've been advised of your right to a jury trial.
So basically meaning that the motion is now set aside, we're resetting the entire process.
Yeah, well, we're resetting for trial. And the question that that Mr. Gromer decided that he would look at for the court, but I'm going to look at it too, is whether or not you even entitled to a jury trial under this circumstance where
Yeah, the audio is not so great. We can hear the defendant pretty well. The attorney though, we can't hear at all, and the judge is really loud. I should have listened to this better before I played it. I just turned the volume up. But when I originally watched this, I could hear the attorney. So I wonder what happened when just turning the volume up makes him inaudible.
you didn't ask for it the first hearing, you entered into a consent judgment that was wrong, and now we're starting over. Does that really absolve you of the right to have requested the jury trial in the first hearing? I'm not sure what the answer is. He thinks it's no. You should have filed it, but we'll see.
Well, I had to do the court.
I don't think he did. She was scheduled for 2:00, and he didn't start his landlord-tenant docket till 3. And when he started it, it was very clear that he was already into the docket. So I don't think he aired it. Part of me wants to say he did that on purpose because that case is everywhere on YouTube, and he may have done that on purpose. She may have requested it. I don't know. But I don't think so. I meant to actually look it up this afternoon to see if there was a resolution to it, because today was supposed to be the last day. So it'll say online what happened in the Register of Action. So I meant to look that up. I did not, but I'll look it up over the weekend and let you guys know on Sunday.
The actual.
Yeah, he's not supposed to lie to me now either.
Well,
He advocates for his position, but he's got to, give me some information concerning that.
might be.
And you can do the same thing, mister, because let me tell you, your motion is here. You can go out there and research what you can and come back and show me what you can. But you'd be surprised what you can do, even though you're not a lawyer. Folks come in with case law and sometimes they're accurate. So you could also research the issue with your new lawyer, if you're going to get them hired that fast, as to whether or not you are currently entitled to a jury trial. So you both can bring in something that says this, and I'm going to give you a date to do that. Okay, so let's get this appearance date. Okay, so let's get a date for this pre-trial first, and we will have you file your responses to the jury trial issue by this pre-trial date.
Available April 11th, 2:45.
So wait a minute. So April 11th. At 2:45 is the pre-trial. So I'm going to ask for some heads up on the motion before April 11th. So that would be, let's say about, if you all could get whatever you're going to be filed by April the 1st, that would be great. So that gives you approximately a little bit over 2 weeks to look at it and just file whatever. You make sure you serve the other side, serve whatever you file. He knows to serve you. Okay.
That's it.
Dated April 11th.
Yes.
Filing by the report.
Yes. Do y'all need an order that says that?
No, Your Honor. Thank you.
So that way we can try to decide this issue on the pretrial date. And then we will also be in a position to set whatever kind of trial date we're having. We'll do that on April the 1st. Now, Mr. Gromer has requested escrow.
Your Honor, if I may. I think one of the issues here is basically an understanding of the amounts that are owed. I think we had an issue with that consent.
Yeah.
And they continue to need to verify those numbers.
Okay.
So, to be fair, there are some complaints that we will be bringing.
Okay. What's that got to do with the escrow?
Well, there may be some injury and some value that may be acquired from the plaintiff for us as well. So
Sure.
All right, so the guy, see, I'm telling you, he might be a professional squatter. He might not actually be, the SovCit vibes are strong with this guy. He doesn't use the script though, like I said in the intro, but he's using delay tactics, asking for a jury trial, on his third hearing, and now he's trying to avoid escrow. Yeah, if he doesn't pay that escrow, he's not going to get his jury trial. And yeah, judge is going to order escrow. You can't get around that.
Oh, no, the court was clear. If possession of the property is at issue, which it is, the plaintiff shows a need for protection, which they need the rent, the court can order escrow. It would be prorated. It should order escrow from today's date to the end of this month, and then you would pay escrow to whatever till rent is due, which would be the next date, I guess would be April something. And then that would be whatever the amount of rent that you normally pay. And you'd keep paying that every time rent's due till we have the trial. It doesn't go to anybody. It goes to me as the court. Then once you have the trial, if I decide, yep, this was the amount of rent due, but there's issues and, your ability to have the premises was affected in some way, and I give you credit against that, then part of that escrow may go back to you. That's what it's there for. It's for the protection of the plaintiff, because I think the rule is there so that, people want to relet their places, whether it's apartment or house, they want to do it quickly. That's why they call these summary proceedings. They're not meant to last for months. They're meant to kind of be heard quickly and get resolved quickly. And so we want to have the money sitting there because we don't want people to just drag a trial out. And then if they lose, they don't have the money to pay. So that's why they put the money in escrow. And that's what the rule really is for. So I will order it because the rule says I should, since I'm putting this out now past a trial date. I don't even have a trial date. I'm having a pre-trial because you want a lawyer, which is fine. But escrow would normally be required in this instance. So let's see. You can agree on what the monthly rent is, right? How much was it in monthly?
1660.
5550 page.
Okay. I was going to do that, but if that's what you say. Yeah, there is. That's why I would usually do this myself. 1665. 31 is 5370.
Yeah.
71 if you want to go over. 5371 per day. And then I've got, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. I've got 12 days here left in March. So it would be $644.52 that you would have to put in escrow with the court. And that would have to be due 7 days from today's date. Then you would pay the $1665 to the court. If your rent's due April 1st, you pay it here on April 1st, but there is a 7-day grace period. And that's what the order says. And then they do not accept personal checks or money orders. Acceptable payments are cash or certified bank checks payable to the 46th District Court. Okay, so let me see.
Yeah, I'm really interested to see if he's gonna have that money paid into escrow. So he wants this jury trial for whatever reason, and I want to see the jury trial. I want to see this guy because I want to see. Again, I believe this guy's a SovCit, and I can't wait to see it. So, but if he doesn't pay that escrow, he's not going to get his jury trial.
And I'm not sure, Mr. Gromer. I think I saw something in my in one of my queues here that the Palace firm was requesting to be removed from getting notices, but we're trying to figure out how that happens. So I'm not sure if you're getting notices on these cases.
They keep setting it.
Okay, but I haven't signed the order because we're trying to figure out how to get it out. Yeah, it's something in the system and it's real tricky. So let's do this order now. 6/44/52. 7 days from to date of today, or might be today. And then you're gonna pay $16.65 per month on the rent. Normally, date rent is normally due. What's your RP number, Mr. Grover?
63503.
65
63
63
503.
50. All right.
Honor, if I might, could you on those dates for the escrow?
Yes. So, 7 days from the date of the order. I'm hoping I get to this order to be dated today. And then the next payment, your normal rent payment, is due whenever your rent was due. If it's due April 1st, pay it here April 1st, but we do give a grace period. $42 West.
First off, thank you so much for the super chat. I do appreciate it, Tupac. This payment is COD. I've got, what is that, certificate of deposit? I'm guessing. I don't. That's what I'm guessing it is. What else would it be? But Tupac, thank you.
Is so case number.
Well, then I was wrong. I guess I'm a young folk that doesn't know what it is. Cash on, cost of delivery? Cash on delivery. All right, well, I'm that naive young person that you were just talking about.
Okay. All right, so I'm getting ready to send this to myself, I think. And we'll get it signed hopefully today.
All right, this one's almost over.
Okay, so I think we're gonna be good there. The order just went up there somewhere for me to sign. And I've got the next date being April 11th at 2:45 for pretrial, and then the brief on this jury demand issue is due April 1st. To give you a chance to look at it. Okay, anybody have anything else?
You say that about the jury trial information, you said refund? I thought you said the refund is due April 1st.
No, I said the brief on the jury trial issue is due April 1st.
Thank you, Judge.
All right, thank you. You're both all set. And make sure you get his number to your lawyer as soon as you hire one, okay?
Yeah, I'm gonna grab this up, Mrs. Carter.
Okay, great.
Dude thought he was getting a refund. Where do I get the refund? Yeah, that one was, I don't know. I found that one really interesting. It was kind of slow, especially with the audio being poor. But I wanted to play that so when the jury trial happens, I don't have to play them both. So we're all caught up. We know what happened. I think that dude's gonna totally SovCit at the jury trial, or he's gonna say some really dumb things. We'll see. All right, moving on. I think we have Judge Simpson next.
You do the same.
Thank you.
Carla Green.
Legal fiction. This super chat adheres to all GAAP. I don't know what that is. Yeah, I don't know what that is. I really don't. Somebody help me out. I don't want to look it up. You guys will tell me. But legal fiction, thank you so much.
Versus Dustin Mickles and Antoinette Mickles.
Your Honor, this is Darnisha Green.
Mark, which I don't want to bring your chat up because you use the P word, but what magistrate's that in the 34th? I don't know what the court that is off the top of my head.
Owner, and Carla's my wife. She's with her students. She's back with her students now.
Okay, well, your name is not on here as plaintiff. So
can you hear me? I'm on here. I just got to do what I got to do.
Oh, okay, Ms. Green, you are on. Okay, all right,
I'm
good.
I'm on here. She was just speaking on my behalf because I'm on the way, but with my students. I work with students with disabilities, and I've been on here for like an hour, but I didn't know it goes like this.
Okay, all right. This is a termination case. And what's your reason for terminating? Is it a month-to-month lease?
Yes, it's been a month-to-month lease since last February.
Pardon?
It's been a month-to-month lease since last February 24.
Yeah, and I actually wasn't gonna play it because of that, but when I don't play something that on that everyone puts out, people are asking like, "Did you see it? Did you see it? Did you see it? You didn't play this." Not everyone here saw it though. So, but this one is good.
Okay, and I see the 30-day notice. And sir, what's your position on being on the termination?
I've been trying to find a place because like our lease, like she said, our lease has been up since, well, it says on the paper since 2/28/25. That's when the lease expired, but it expired last year, that day. But I've been looking for housing and stuff like that. But I came into this house out of a program through the Alpha House, which is through Hawk. And I was given Section 8, and then they took my housing voucher from me. And so like I've been trying to find somewhere else, but I have a big family. And so I've applied for 23 different places and I've been denied. And
when you say somebody took your housing voucher, who took your housing voucher?
I think it would be RPI.
Okay.
And with
is that the arraignment? 134. That's the DDC, right? I call that the arraignment mill. I'm pretty sure it's 134. How did someone get on Zoom there? They don't. That's weird. That sucks though. That sucks. Why are they? I hate that.
Sorry.
When did that happen?
It happened in November. And then the program agreed to continue paying the rent. While I looked for a place, and I tried to explain to them I can look, but since my family is so big, I have to have a certain size. And
Gotcha.
I haven't found anything, sir. And the ones that I have found, I went to private landlords on Facebook, and a lot of those people are scamming.
Well, but let me I'm just trying to understand this. Right now, if you try to move, you don't have a voucher.
No, they took it from me, sir.
Okay,
Because,
no, I heard you. Just listen to my questions. I'm just trying to sort it out.
Okay.
And so the landlord in this case, Ms. Green, they haven't been getting anything paid they haven't been getting anything. Is that?
No.
When you say no, am I correct in what I said or?
Correct.
Okay, all right. I just wanted to make sure. So let me ask you this. If his voucher, because I don't understand why they removed your voucher. And I'm not going to be able to sort that through today. I'm just trying to figure out, are you terminating because he doesn't have the voucher any longer and you're looking at the picture there? If he had the voucher, might this tenancy continue?
At this time, I'm just done with the whole rent thing. I don't want to go through these court proceedings.
He said 9. I don't know if that means he has 9 kids or his family is 9, but he did say 9. So it's either 7 kids or 9 kids, so that makes 11. That's his household size.
No, they didn't get the
You don't like coming to see me?
Absolutely not. I'm not a court chick.
Whoa. I'm now okay, Ms. Green. Now I'm hurt.
It's nothing towards you, but I'm just not. But
I got
the family really they took care of my property and everything. It's just like the system failed them, and I feel bad about it. But like I don't want to go through this whole process.
You mean in terms of the voucher being taken and?
No, they was in the shelter program from the beginning.
Okay.
And the lady, their worker, did never follow through on anything. And so when she was the person that's supposed to help them get the voucher and help them. She failed them. I told this young man, it seems like he could do something legally with that, because how do you end up in a shelter and still end up homeless?
Yeah, no, I hear you. And that's why I was asking the question I was asking, because of something that Mr. Mickles said. Because it sounds like as long as the voucher was there, things were okay. But something happened with this voucher and the worker. And that, Mr. Mickles, how many people do you have in your household?
9.
Oh, boy. Okay.
One of which is a 3-month-old baby.
Okay. All right. Here's what I'm going to do. Have you talked to legal services at all?
No, sir. I tried to do some research about it, but I really haven't had much time because, like, we have been packing the house up, and like I work midnights, and my kids.
All right. Listen. Write this number down.
One moment, sir.
Your Honor.
Yes.
This is Darnisha Green, a co-owner. What my wife is not sharing with you is that we haven't received payment. And like we feel for the Mickles family, but we can't afford both homesteads either. We have 5 people in college.
Okay, was anybody listening to what I just said?
Yeah, you said contact.
Here's what I'm indicating. I don't know if the reason I was asking is, could the tenancy continue if the voucher was there? I get the fact that there wasn't any payment. I understand that because the voucher got taken. My only question is why was it taken?
Regardless to the fact we want possession of our property.
All right, you need to put your name on the case because I'm just,
Well,
Okay.
Carla, you
I
need
got
to,
a family.
because
with
I'm the
kids.
one
No,
paying the
ma'am,
bills.
ma'am.
Okay.
My court.
Ju-
This is the way
ju-
it works.
I
Okay,
I
understand,
will
but
let
I'm
you
going in
talk,
default. I'm going into
but
default on my bills. This is not, this is a
Okay.
ripple effect.
Okay, Your Honor,
ma'am, I'm
I
gonna kick you
understand.
out. I'm gonna kick you out of my proceeding.
Bye.
She
Kick
finna
her.
log off.
Bye. Kick her
She,
out. She's gone.
she finna log off. I apologize. For that, Judge. I apologize, but
You let her know she does not address me that way ever.
okay, I apologize. She just upset. She's putting her daughter
She can
through
be as
hard work.
upset as she can be as upset as she wants. I'm just going to ask the questions that I've asked. I've got somebody with 9 people in this household.
Okay, but
I've
I
got
can't
you
take
not
care of
getting
my
paid,
family. Right.
and I get it. March 28th, I'm going to adjourn it out 1 week. Let them contact legal services because here's what it is, Ms. Green, and what the problem's going to be. If he's got 9 in the household, I mean, it's going to be a bad situation all around, or can be, because I don't know a place that's going to be able to take 9. And so he's going to have a voucher to get himself out. And so I want to
So
give a
in the
chance for him to
meantime,
try to talk. I want to give a chance to have him talk to a lawyer to see why they terminated the voucher. All right. And then sort of work from there. Okay.
The landlord doesn't want to wait. Judge Simpson wants to figure out why the voucher was terminated, and she started saying, I'm going to go in default because I can't afford to pay both houses with no one paying rent on the house that he lives in. And then she kept over talking Judge Simpson, which we all know that's not what you do. So he kind of said, stop. He's like, we're not playing that game. And then she's just like, peace, I'm leaving. Yeah, that's what happened.
Did I give him the number?
No,
but what I'm
Okay.
but what I'm trying to
Yeah.
tell you, Judge Simpson, whether he get the voucher or not, I want my property.
No, I got you. But if that happens, it's going to be he can potentially move, but I've got to give him the opportunity to look at why the voucher was taken.
Okay.
Okay. All right. Sir, here's the phone number.
Okay.
All right. Area code 734.
All right. I was ready to mute it. I forgot I just cut the rest of that off. There was nothing left. So you didn't miss anything. But yeah, I understand why she's frustrated. Absolutely. Yeah, she still has to go through the legal process, so can't act that way in court. But yeah, her position's understandable. I think that's why Judge Simpson just got mad. Like, okay, you got to tell her instead of going further with it. All right, let's just move on. We're jumping down to Texas and with Judge Garcia. We got another landlord-tenant case. I know we're packed full. It's Friday. Friday's landlord-tenant day.
Yes, everybody got this. Point East versus Blake.
Point East here, Your Honor.
Then they go ahead and get it started. What is the monthly rent?
Okay, the monthly rent is $875. There's no government subsidy. Has a balance in January of $98, owes all of February, all of March, which is a total of $1,896, strictly rent.
Mr. Crump, first of all, do you agree that your base monthly rent is $875 a month?
No, it's $899.
Is
I
that
beg
what-
your pardon. I beg your pardon. It is $899, Your Honor. Sorry.
Okay. So we corrected that. It's $899. So again, Mr. Blake, do you agree that your monthly rent is $899 a month?
Yes.
Okay. Do you agree that January was paid but not the full amount?
Of $97, which rolled over from December of
Okay.
last year.
And then do you agree that February and March were not paid?
Because she denied it. And I got witnesses that stated.
Okay. And was it paid in full?
I was getting ready to pay it in full. But
Was it paid in full when you attempted to pay it? Not you were going to pay it. When you went in there to make your payment, was it the full balance?
yes,
amount?
it was.
Okay, so that means you have all that money saved, correct?
Mm-hmm.
Okay, so right now your balance is 1896. Can you become current with $1,896?
Well, I was aware from my counselor team because I came in there through One Haven for Hope, and the apartment unit is not livable.
Okay, and you can find that another way, but you decided to stay in that apartment. You were
That's because my mods are awesome. They see a Cheshire cat coming my way at about 9:15, and they take out the squirt guns and the hoses. Speaking of which, how are you doing? Are you better? I know last night I think you said your hand was bothering you. Hope you're better today, bud.
currently in that apartment.
My housing stuff just started getting complete, and when the people came out to evaluate the apartment,
It failed inspection.
it failed inspection.
When did it all fail inspection?
As far as I know, sometime last in December or something.
Okay, so I've been working with housing pretty much for years. And if they fail inspection, they give you another voucher to move out, or they give you a
Well,
time
that's what
frame.
we're working on now. Maybe for hope they're
But
working on that.
You chose to stay there for an
Well, I've
extra
been
3
there
months.
for 7 years though, ma'am,
So you
and
gotta pay rent, sir.
I have been paying rent.
Okay.
They denied my rent for $97.
Okay.
Now I came in there with February and March. February with, and when I came in, whoever the lady was, because in December, my rent is, the way that they have it is set up to where we pay the person who's on the lease.
Okay, so you came in and tried to pay February and January's rent. So do you still have those money orders?
No,
Where's that money at?
I put it back in my bank.
So you have it in your bank?
Yes.
Okay, so what about March?
March, they denied it.
So are you gonna pay March? Because we're already at the end of March.
No, they denied it, so how am I gonna pay somebody?
Okay, just because they deny it, the court is asking you, are you going to pay March? Because you have been in the premises and you owe March, whether they denied it or
I'll
not.
be able to pay for March in April.
Miss Cindy, what do you want him to do on that?
Your Honor, I'm looking at his ledger right now. He's never been on housing. He's been there since 2005. He's never been filed on, but he fell behind in January with $98. His last payment was $800 on January the 1st. Beg your pardon, January the 6th, he made a payment of $800 toward his January rent, which left him with a balance of $98 because he had a dollar credit in December. So then he owed $8.99 for February and $8.99 for March.
Some vital information and you're not paying attention. She is literally going through everything and you're too busy chit chatting over here.
No, because he asked me a question,
I
man.
need you to pay attention to
Okay.
her testimony because you're gonna be asking the same questions she just answered for you.
Who am I looking at? I don't even know who I'm.
Go ahead, Miss Cindy.
Okay, and so he hasn't made a payment since January 6th. And of course, his ledger balance is $2,067 because it has the court fee on it. So that might have been a reason why, but we usually will take the rent and then the court fee, we work with them for the following month. But right now he does owe $98 for January, owes all of February and all of March.
So right now, he's got the $98 and he's got February's rent in his bank, according to him, correct?
Mm-hmm.
And he needs till April to pay March.
No, we need March also.
See that?
We don't carry over rent. That's one policy we have, is we don't carry our March rent into another month.
Y'all gave me this after when y'all found out that apartment was not livable. I have been complaining to y'all about the unnecessary deal. Y'all got it on y'all portal that we're not allowed to pay rent on portal, which the lady, whoever that lady was, because she was not April. The lady that was in there, I don't even know who this lady was. This lady didn't even have a name tag or nothing. She just presented herself and she told me that she is not going to take my $97. Now up under penal code 97 code dash, she has to take my money. And she denied it. And I actually asked her, is the office or the companies denying the $97 or are you doing it? She said her. I asked her, who is she? She said she's the manager. I said, well, where is Wendy? She said she's no longer here. I said, well, how long you been here? Because we get managers in there every other month. And some of them,
Wendy is still the manager.
and some of those people had literally April, I'm talking about April. Literally, some of them people has took our money. And we are getting
Again,
tired
Mr.
of that.
If you want to hire an attorney, you're more than welcome to.
I'm waiting on, soon as my attorney, soon as my counsel lead from Haven for Hope, Mr. James Gomez, Henry Gonzalez, his son, I'm waiting on James Cross, Brian Cross. All of these was my sponsors. So I'm waiting on all of them to come in from.
Right now, my question to you is January, February, and March of code. They want 1896. Can you pay that today?
No, I cannot.
Our judgment's gonna be in the amount of 1896. Again, you've got 5 days to move out, 5 days to appeal it, or try to work something out.
I'm going to appeal it.
Okay. All right.
Thank you, Your Honor.
I want to appeal. Now.
That's all I have, Your Honor. May I be excused?
Yes, Ms. Zini, if
Thank
need
you.
permission
Thank you very
on
much.
process, you can ask the clerks in the front. Okay?
Where, ma'am?
You can ask the clerks in the front at the window. Okay. That's it.
I'm gonna appeal it. I'm gonna appeal it. You're not paying rent, man. That's it. There, it does suck that he's lived there for so long and he fell behind a little bit, and they're just like, nope, not gonna work with you. But if the place is unlivable, then yeah, the landlord wants to get you out so they could fix whatever the problem is. Anyways, let's move on. I think that's it for landlord tenant. 1 second. Oh yeah, this guy is just a weirdo. This is a really weird case, and you'll see why I put this on here. But Washington, this is Thurston County. Let's go.
So this looks like on a conditions review on 2 Lacey cases, and now a new
Sorry, Lacey.
preliminary appearance on a domestic violence related offense. So we'll start. We'll start with the new charge. Did you review your legal rights on this sheet of paper with Attorney Gallegos up there, Mr. Burnfield?
No, I did not.
With Ms. Clark.
He did with Ms. Clark.
Okay. Any questions about any of those rights?
Yes.
What questions do you have?
I'm unaware of what I'm being held on today.
Okay, we'll get to that. We'll get to that in a minute. I just want to know if you know what your rights are. So it's like the right to remain silent, right to an attorney, call witnesses, and so forth.
Yes, sir. Yes, Your Honor.
We'll get to the charges in a minute. And then, in fact, I'll ask right now, Mr. Lindgren, what's the state seeking probable cause for on the new charge?
Violation of a no contact order, Your Honor.
So the charge, or what state seeking probable cause for, nothing's formally been charged yet, is violation of a no contact order. Attorney Gallegos, do you have a position on probable cause?
We will stipulate probable cause for this matter, Your Honor.
So I'm going to find probable cause for violation of a no contact order. We're going to set conditions of release. And then we're going to hear from the state on conditions of release. Then is the state representing or have thoughts from Lacey about what they want to do with the cases that are pending in Lacey?
I believe bail amounts that Lacey intends to propose, Your Honor.
Okay.
That's it.
Intend to request.
Yeah.
What's the state's position on conditions of release on the new charge?
Your Honor, the state is seeking, well, first off, I should say the defendant has a harassment charge out of Lacey from December of from 2024. That is on a deferral. My understanding is that involves the same victim. In this case, the civil protection order at issue was issued just on Friday, March 14th, 2025. So the defendant violated it pretty much right after it went into effect. So the state is seeking $10,000 bail, no criminal law violations, no firearms or deadly weapons, and NCO or abide by the existing NCO. And yeah, and that'll be it, Your
Honor. And then what's Lacey asking for? on the conditions of release. Then Attorney Villegas, I'll come to you, and then Ms. Langley, I'll hear from you. Lacey, what's Lacey's request?
I apologize, Your Honor. In this case, Lacey is asking for $50,000 bail on each case.
Attorney Villegas,
Yes, Your Honor.
I'll hear from you on conditions of release.
I'll handle this, Your Honor. So, Your Honor, we're asking for a PR here. These are merely allegations, though we did stipulate to probable cause for purposes of today's hearing only. I would note that there is an interesting legal issue here in that Mr. Burnfield had not actually been served with the document in question. There's an argument that he may or may not have known about some part of it, sufficient, we believe, for probable cause, but nonetheless, a real argument here about whether he had been served with this document. He has no criminal history whatsoever. The Lacey allegations are allegations, and this is a nonviolent allegation. The presumption here is release, and so we are asking for the court to release Mr. Burnfield.
Oh, here's the twist. The twist is about to come. The judge is about to drop it right here. This guy, I don't know why if we were going to try to mess with anything in the court process, it would be this. It would be this right here.
Ms. Langley.
Your Honor, I guess I would also ask for his release, but if the court sets bail in the county case, then I'm going to ask for only nominal bail in the Lacey cases. He has absolutely no money. His struggles have been based on the fact that he and his family have been like placed in a hotel room, not having a car. It's been, his life has been really, really challenging. I think.
Did you see his, okay, hang on just a second there. I was going to get to this in a minute. You might not have seen it, but I have to admit to you, I'm a little bit bothered by the way he filled out his indigency screening form. I don't know if anybody had a chance to read that.
Look at him. He's hiding now. He's like, oh, man, I done messed up. What are you hiding? That's just weird. That's a child move. You're a grown man with kids.
Ms. Millar, did you read that?
It was completed with another individual from our office, Your Honor.
Okay. Well, just as an example, when he says he claims to have $1 billion, he's on a salary for $500,000 a month, which frankly kind of leads me to wonder how seriously he's taken all this. Unless he really does make that amount of money. I was just told by Ms. Langley that he doesn't.
He does not, Your Honor. That was some frustration. We apologize to the court.
Well, then maybe you can go back. He can redo his indigency screening form, and then we can recall his case in a few minutes.
Your Honor, I'd also just like to say before I forget that I've just been informed that the victim
I saw that. We're not done with this hearing yet. He's going to go back and refill that thing, and then we're going to resubmit it.
Yeah, he's kind of lucky that the judge he's a good judge. He's nice, and he could have just started out like, nope, I'm not doing it. You're representing yourself now because you make too much money. Go hire an attorney. He was absolutely in his right to do that. That is not a form you want to mess up on, and I'm pretty sure that's under you fill that out under oath. You're not allowed to lie on the financial responsibility form. At least I'm pretty sure he could get in trouble for that.
So Christina Burnfield is on the Zoom call, or Shar Burnfield. Sorry about that.
Yes, if you can give me just one moment, I can get that baby to stop crying.
Ma'am, I can't even hear that, so I think it's fine.
Okay.
Hey, Dawn. Like every other day? Yeah. Kind of batshit crazy. A little bit, yeah. Crazier than I'd like.
Okay, so
We're not muted.
Thank you, Ms. Millar. I'm not sure how that happened, but thank you. Okay, so give me just a second. We'll come back on conditions of release based on the new
It was something in the jail was going on. The mic just picked it up. No idea what it was.
emergency screening form. I will appoint Thurston County Public Defense to represent Mr. Burnfield. And give me just a second. And I skimmed this earlier. I'm gonna read this in a little bit more detail now.
And, Your Honor, just for clarification, I want to make sure the court is aware that our clients are presented with these screening forms without us present, and sometimes the information on them is not complete. So this one that we did this prior to court. It simply didn't make its way over until now. So I wanted to make sure the court was aware of the situation.
So I wasn't supposed to see the first one, is what you're telling me?
The jail attempts to assist by moving things along by providing these forms, but the clients don't get assistance in filling them out. And so 2 different forms were produced in this situation.
Oh, okay, thank you.
I think the mother of his kids that's on the screen right now wants to know where he's hiding all of his money. He's got $1 billion. Makes $500,000 a month, and they're living in hotels. What's wrong with this picture? I don't like dead time. Somebody start talking. Oh, he's not done. He's gonna turn into a giant baby here in a second. Spoiler alert. Sorry, guys. I don't know why I just let that go so easily. All right. I might fast forward a little bit, guys. 56:15.
These are all just allegations right now. There was.
All right. I fast forwarded 20 seconds and they're talking, so we'll just let it go.
Okay, so Ms. Burnfield, do you wish to be heard on this? We're talking about conditions of release and order, and I read there, and again, as far as I can tell, there was some alleged, these are all just allegations right now. There was some text back and forth between you and Mr. Burnfield saying an order is going to be in place. He came to your place, and then, let me finish, ma'am. Then law enforcement got involved, and then law enforcement conversed with him, telling him there was going to be an order. Don't come there anymore. And even though they never formally served him, they did provide notice. He came out again anyway. And then that led to him being arrested. So, and that's just might be an oversimplification of everything that's alleged, but that seems to me to be kind of the long and the short of it. So Ms. Burnfield, again, I'll hear from you if you wish to say anything at this point.
My biggest concern is just like I have no problems with him being out and being around me and the kids when he's sober, if he can remain sober. That's my biggest concern.
And then
because he's so unpredictable when he is using.
Do you have a hearing set on the no contact order in Superior Court?
On the 28th, yes.
So Ms. Langley, I don't know that I've heard from you just yet. Do you have any, or yes,
Partially, I think, Your Honor. I think just to wrap it up, he simply doesn't have any money. His lack of money has been a struggle the whole time I've been representing him, and I'm going to ask that if bail is set, which I hope it is not, that it be nominal. It will probably hold him.
all right. Give me just a second. So tell me again there, Ms. Burnfield, it's just going to come back to you. If I'm understanding you correctly, do you view this more as an alcohol issue than a safety issue, or both, or
No,
what exactly?
I would say both. When he is using, I mean, the harassment charge alone was based off because of a threat that he made to me when he was high, and I was pregnant with his child. I mean, we have children ranging from 14 to 6-month-olds in our house, and his mood and his anger, it fluctuates like a roller coaster ride. One minute he's fine, and the next minute the smallest thing sets him off, and he's threatening to kill me and bash my face in. So, I mean, that was based off of an argument of a game a kid had on a tablet. Like, that's ridiculous. That's a bit much for
All right.
a game. So.
He has multiple charges. That's why he has two different attorneys. The Langley is the attorney on one of his cases. The attorney sitting next to him is just a part of the public defender group that's handling his arraignment. But Miss Langley is covering his other case that's already in the works. That's what's going on. The woman that was just talking is the mother of his children. I don't know if it's a wife, an ex-wife, a girlfriend. I don't know. They probably announced it. I didn't hear it. And the incredibly good-looking gentleman in the top left, that's the judge.
Thank you, ma'am. Ms. Langley, when's the next court date in Lacey?
Oh, I'm not sure. I can check.
I'm told April 6th.
Okay, yeah, I'll
April
accept that.
16th at 10:30. Okay. April 16th at 10:30. Give me just a second.
Your Honor, just to be clear, if the court's concern is substance use, Mr. Burnfield has no objection to the court imposing least restrictive conditions in the form of restrictions on substance use.
Well,
there was one already. Sorry.
Okay, yeah, and I thank you, ma'am. And frankly, ma'am, Ms. Millar, thank you, but it's both. It's both. So on all of these charges, I'm going to set bail in the amount of $1,000 cash or bonds. All prior conditions remain in the late. And Ms. Langley, we're going to move your court dates in Lacey. We're going to move them up.
Okay.
On the state case, the conditions are: don't have any criminal law violations, don't consume any alcohol or have any controlled substances out of valid prescription, don't refuse a breath test, stay out of bars and taverns. We'll set a court date for March 26th.
Yeah, I've kind of been zoning in and out during this video tonight, guys. I am tired. Last night took a lot out of me. I was up really late. I know we didn't stream terribly late, but afterwards I stayed. I talked to Skeptic a little bit, then I talked to Chuck, and it was just a really late night. So I am beat. So yeah, I'm not really paying attention, which is bad. I shouldn't admit that. I really shouldn't. But we're almost finished, guys. Don't worry. We're getting there.
We'll start at 8:30, but if he's still in custody, that'll need to get set over.
I'm not normally here on Thursdays, Your Honor.
What's that? No, that's the state case on the.
Oh, okay, sorry.
Give me back. And that's a Wednesday, by the way, I hope.
Oh.
Yeah, March 26th is a Wednesday for the state case. For the Lacey cases, it'll be $1,000 on each case. All prior conditions remain. And we'll move that up to Ms. Langley. I can do that as soon as next Monday if you wish. We can just put it on the morning calendar. If he's still in custody, then that'll need to get set over.
Sure, that'll work, Your Honor. Thank you.
And on the 316, I think that's a pretrial. And the other case would be pre-FTC.
Mm-hmm.
So it's at March 24th at 8:30 for pre-trial.
Well, remind me on the 26th to wish you a happy birthday. My birthday's on the 27th, the day after you. And it is KCC's birthday on the 25th, I believe. I believe it's the 25th. It might be the 24th. I know it's within just a couple days of mine. I want to say it's the 25th. Got a lot of March birthdays. And I feel like Mikey's birthday is around this area, around this time. Maybe not. Someone else. It might not be Mikey. Somebody. I don't know. All right, let's continue.
trial.
Sly.
And I know Your Honor's looking at something. I just wanted to let the court know that Mr. Burnfield wishes to address the court. I've advised him of his right to remain silent, but he wishes to address the court.
All right, give me just.
If you're referring to why he didn't release the video, he was gonna record it last night after the live stream that he had with me, and afterwards I spoke to him for about 10 to 15 minutes, and he sounded like shit. You could just tell he was tired, and I was like, dude, people can wait. Put it out on Saturday or Sunday. You need to go to bed. So I forced him to go to bed, and I'm glad he listened to me. So he actually went to sleep because he was traveling today. He's going to record a video, edit it, put it out, and then travel to another country today. It's a bad idea. So I'm glad he listened to me. So we'll probably see it tomorrow. I would say Sunday at the latest, if that's what you're asking. I guess I don't know if that's what you're asking about, but yeah.
Just a minute. Oh, shoot.
1 second.
So yeah, the Lacey case will be March 24th, a week from today. Both Lacey cases. And then, yeah, and so that'll be it. Mr. Burnfield, you wanted to say something?
Yes,
Again, I'm going to let you, I'm going to be fair with you up front and saying that I tend to doubt that you're going to be able to say anything that's going to change my mind based on what I've heard. But on the other hand, I'm not, but go ahead if you wish to say something.
Yes, Your Honor. I just asked that if there any consideration of letting me be released PR again today. I haven't done anything wrong, Your Honor. I got arrested before I was even served the paperwork that said there was a protective order. That's all I wanted to say. And they asked me to come back to get served. That's all, Your Honor. That's all. I don't have any money.
Okay. No, and so that's
What happened to the billions? I don't believe this guy has $1 billion. I think he lied on that piece of paper. I've been thinking about it this entire hearing. I think he lied. You just can't trust some people, especially the people in jail, I guess. All right. That's about it, guys. There's only about 10 seconds left of this video. Thank you guys so much for hanging out with me tonight. I do appreciate it. I do apologize for being a little tired. I think I did a good job pushing through it, but I really wasn't paying too much attention to the videos. I was just staring at the chat. But you guys are awesome. Thank you for the super chats. And we are going to raid Lone Wolf tonight. Yeah, I already set it up. So let's go over there and say hi to him. I will not be seeing you tomorrow. Tomorrow night is my date off. My date off. It's my night off. It's date night. So I'm going to take tomorrow night off. I've got a really good video to release in the morning. So make sure you check that out. And I will see you guys Sunday night. Yep. So have a great weekend. Don't do anything dumb. You don't want to end up on my channel. If you do something dumb and you're in court, make sure you do something dumb in court as well. So then we'll, get thousands of views. That sounds like a good deal. Maybe I'll throw you a PayPal for it. Don't do it. Don't do it. That was a joke. No one take that serious. I will not be giving you any money for going to jail. I will tell you this right now. All right, you guys are awesome. Go tell Lone Wolf I said hi, and I will see you guys Sunday night. Until next time, bye.
my decision is going to remain. And like I say, you'll have a court date within a week and then within 9 days. And so some folks will be up to talk to you. But that'll be it for today. Do you have another case in court?